What are the remedies available to a party in Scotland? Well, broadly speaking, there are 5 main remedies. In Scotland, our judgments are called decrees, and so we have decrees for payment or for damages, decrees declaring a factual and legal position, such as a declarator, decrees reducing contracts or deeds, decrees interdicting something from being done, and decrees of specific implement requiring something to be done.
Decree repayment is self-explanatory. It's payment of a sum of money due under a contract. Damages can relate to both contractual and delictual obligations. In English law speak, that is damages arising from a contract or a tort. These are purely compensatory, and the Scottish courts do not permit punitive damages unless they are allowed under statute.
A decree of reduction has the effect of annulling a deed or writing. An alternative to seeking reduction is to ask the court to set the document aside ope exceptionis. That's a nice little Latin phrase which has crept in from our civil law background. Basically, what that means is that the court will set a document aside as part of a broader action, in which case the invalidity of the document has no effect beyond the particular litigation. Interdict is the Scottish equivalent of injunction. It is a remedy granted by the court either against a wrong that is in progress or one that is reasonably apprehended. Where a case has been fully considered at proof and evidence has been led and the defender's actions have been found to be unlawful, the pursuer is entitled to interdict alongside whichever other remedy may be sought. If an interdicted party fails to observe the interdict, he may be liable to punishment by fine or even imprisonment.
Interim interdict may be granted on a temporary basis during the currency of a litigation to prevent an imminent wrong from happening. Before it will grant interim interdict, the court must be satisfied the party has made it a prima facie case and the balance of convenience favours the granting of the interim interdicts. Interim interdict is granted at the risk that damages will be awarded against the applicant should the interim interdict be recalled or perpetual interdict be refused and the defender has suffered loss as a result of the interim interdict. Another little Latin phrase we like to use is that interdict is sought periculo patentis.
Sounds like a spell, but it just means you take it at your peril. Specific implement is where the court orders the performance of some act which the defender is under a legal duty to perform. The decree is called a decree ad factum praestandum. I told you we liked our Latin phrases. An example of specific performance is a decree for removal of an encroachment. Decrees sought must, however, be specific. That's so the defender knows what's expected of them, and performance must be possible. You can obtain an interim specific implement as you can an interim interdict. The court has to be satisfied that there's a prima facie case and that the obligation sought to be implemented exists and that the balance of convenience favours the granting of the interim order. There are other interim orders that can be sought, for instance, an order for delivery or removal.